Okay. We have 2 more people joining. Perfect. We've reached 50 people. That was what I was hoping. Anyone else who joined, I'll still let them in. Letty, can you see the screen? Can you say yes? You can see the sparkle? Everyone?
Yeah, I see it.
Okay, thank you. I might ask a question. If you can just respond for the group because, there'll be no more questions. Okay. So everybody, my name is Andrew Dennis. I'm the owner of Ibis Prep. I have a JD MBA from the University of Miami, class of 2016.
And I think in this particular instance, if I remember correctly,
I have to mute all. All right, sorry about that, but I just muted everyone. I graduated from UM Law, Miami Business. Passed the bar on my first attempt. It was a grueling process. I've also passed the Series 7, the Series 66, which are really hard tests for finance professionals. But I'm with you guys. The Florida bar is the hardest thing I've ever done in my life. It's the Mount Everest. It's everything you've been preparing for. Law school doesn't do necessarily the best job of preparing you for the test. And then Barbary and Kaplan, these other companies, they do their best job. But at the end of the day, it's still a really, really, really hard test that you need to dig deep within yourself and find all the resources available. So we're here today to just add one more resource. Leticia Mora is here with me as well. She is a practicing attorney. She also passed the Florida bar exam, and she is currently tutoring a few students who are here in this room, I believe, a few students overall. She's in the mix right now, meaning she is really competent on all subjects. I am too. I tutor a few students. I stay very active on every subject. Okay, so enough about us, because it doesn't matter who we are. It matters what we can do today to help you. What day is it? It's today, my favorite day. I need you guys to be positive. Today is a very important day in the life of a young attorney. It's a few days before the bar exam. Every day is meaningful. Let's make today as valuable as possible. Ibis Prep, my company that I founded here in Miami, we're a tutor for every subject under the sun, and we prioritize education above all else. We do offer one-on-one tutoring for every subject under the sun, including the Florida and California bar exam. So, if you guys find this valuable and you want to reach out to us, maybe do an hour session before the exam, or you have a friend who's going to take it in the future, just keep us in mind. Who are we? Again, Andrew and Leticia. We have, most importantly, passed the Florida bar, and that's what we're here. I'm not going to boil you down with this. We're going to get right into it. I just wanted to say, these are the numbers from February. You see, only 60% of people passed in February. That's just the reality of the test. It's a very difficult exam, and you got to be over-prepared to overperform. So I don't want to be negative in that context. I just want to let you know that, you really, regardless of what happens, regardless of Florida bar, kind of putting you guys in a really difficult situation, it's still going to be somewhere around this passage rate. So you got to be ready. You can't take anything for granted. All right, ladies and gentlemen, let us begin. I'm going to do the first section, which is commercial paper. Letty's going to do the next 2 sections, which are going to be con law and torts, and I'm going to finish with trusts. Now, commercial paper is a subject near and dear to my heart because, I'm involved in securities. But for most of you guys who are taking the Florida bar exam, it's something that you've never really had experience with. And it's something that I would never recommend you don't know thoroughly because it could be tested. And if anything could be tested, I highly recommend that you know it thoroughly. I would never play Russian roulette with the Florida bar. So here I'm going to run you guys through the commercial paper outline. And this means if you see a commercial paper essay, this is the outline that you're going to recite. These are the issues you're going to touch upon. However you are tested on commercial paper on this exam, just know there's not that many things that they could test you. If you understand the basics of commercial paper, you will do well in a commercial paper outline, regardless if you are an expert in it, as long as you know the foundations of commercial paper. And here I'm going to give you the outline. Okay, is the instrument commercial paper under Article 3, right? We're going to get an essay. They're going to be talking about something. That's the first thing we need to ask ourselves. Is it commercial paper? What type of commercial paper is it? We need to identify the parties. Then we need to we're going to need to drop the definition of negotiable instrument. and see if this instrument satisfies all the conditions of negotiability. Then we see, has it properly been negotiated? And that's usually an endorsement if it's, it doesn't always have to be. Are they a holder in due course? We'll consider the shelter rule. Then we'll go through the real defenses, which they're subject to, and not the personal offenses, and transfer warranties, presentment warranties. This right here, take a snapshot with your eyes. If you can drop these points on a commercial paper essay and have some truthful understanding of what it is, you will do fine. I want you to know that. Don't be scared of commercial paper. It should be a topic that you want to encounter, because anyone who didn't come to this might not have even studied it ever, and I'm going to give you the basics. Okay, first thing, is it commercial paper, right? Article 3 doesn't apply to money, payment orders, or securities. Do you guys understand what a security is? That typically means a stocks or a bond, right? Securities. It only applies to these written instruments, so certain written instruments that we'll get into. So you'll be able to identify a commercial paper on the exam. It'll be some sort of check or some sort of payment that you'll see has these conditions. Now there's two types, right? There's notes and drafts. So we answered the first question, is it commercial paper? Then we'll go to the second question. What type of paper is it? And specifically, I'm asking, is it a note or is it a draft, right? Notes are two-party instruments. Drafts are three-party instruments. When you think of a draft, you simply think of a check, right? You have the person who writes the check, the person who's going to cash the check, and then you have the bank. The bank is going to be the third party. So when you look at a commercial paper question, you want to identify, is it commercial paper? Is it a negotiable instrument? And then what type of paper is it? Note or draft, and who are the parties? You have the maker, the person who will pay, the payee, the person who gets paid. That's for a note. And then for a draft, we have the drawer, the person who writes it, the drawee, the person who's ordered to make the payment, that would be the bank, and then the payee, the person who gets paid. If you can just take the due diligence to go through the beginning pieces of this, you're going to get some solid points. So please make sure you understand those basics. That's 1, 2, and 3. Is it commercial paper? What type of paper is it? Meaning, is it under Article 3? And who are the parties? If you guys have any questions, by the way, ask them in the group chat and Letty will try and answer them. I'm going to be talking, but we're going to, we're a two-team party right here. Okay. Welcome to the room, Beth. We just did 1, 2, and 3. Is it commercial paper? Who are the parties and what type of paper? A note is a two-party, draft is a three-party. Okay. Every single person in this room must have this definition memorized. Close your eyes and say it, right? A signed, written, unconditional promise to pay a fixed amount of money plus interest on demand at a definite time to order or bearer with no additional undertakings. The Florida Bar examiners love definitions. If you can drop a definition word for word, you will get the points, right? And I'm doing, the reason I chose to do commercial paper and trusts, honestly, is a little bit selfish, because in my mind, I think they're two of the easiest essay topics. All you need to do is really remember the definition and then do your due diligence during the essay to go through all the points. Is it signed? Is it written? Oh, is this condition? Well, they may consider it, play both sides, but that's what the bar examiners are looking for. Do you know the rule, and can you go through each element of the rule properly? Remember, this is the bar exam. This isn't a law school paper. You need to overstate things. You need to act like you are trying to prove you're the smartest kid in the room and you know everything about commercial paper. And commercial paper is negotiable, right? I'm not trying to talk like that, but signed, written, unconditional promise to pay a fixed amount of money on demand or definite time to order or bear with no additional undertakings, right? You guys all have this. This isn't new to you, but it must be memorized. So that's number 4. We've gone through the instrument. Is it negotiable? Okay. Well, then what? We have to negotiate it. And now just keep in mind, if we're talking about a negotiable instrument, I always like to think of a check, right? As we remember, a check is just a simple draft. It's a 3-party instrument. And if I'm just thinking about a check, it makes things more like, okay, I understand this. So how do you negotiate a check? Well, you sign it, right? You sign it off to someone. You sign your name on it, and they sign the back of it, whatever it may be. If it's bearer paper, all you need is to have it, right? Technically, checks are we don't want to really get too bogged down in the example, but what I want you to focus on is the test and what they're going to show you. Bearer paper just means you only need to have possession of it. Whereas order paper means that you also need the endorsement, the signature. And this is I hope you guys know who John Hancock is. That's the signature, right? So again, I'm going through the 5 steps. I'm trying to reiterate and do it methodically because I'm sure there's a lot of people in here who have no idea what's going on with commercial paper. I'm trying to dumb it down for you. Just go through these steps. Is it commercial paper, right? Is it something that is a negotiable instrument? Is it a note or is it a draft? Is it a 2-party or a 3-party? Are we talking a maker and a payee if it's 2-party? A drawer, drawee, and a payee if it's 3 parties? Now, big one. We have to use the entire definition of the requirements of negotiability. Then, if we go through that entire analysis and see that it has all those things, we have to determine, was it properly negotiated? Again, bearer paper is negotiated simply by possession. Order paper is by endorsement. Pretty simple, you know. I know, like, in my mind, there's 1,000 thoughts coming up right now. Like, Andrew, you're not mentioning X, Y, and Z, but I'm not trying to confuse you guys. I'm trying to make you all competent enough to just be able to do a basic commercial paper outline. And if any of you guys are sitting back right now, you're like, come on, duh, that's good news, right? That's the best thing possible. You want to be like that in every single subject. Like, come on, duh, I know this, move faster. You know, if I'm moving too fast for you, that's not the best sign, but it's okay. There's still time to learn everything. All right, holders in due course. So we've gone through, has it been properly negotiated? Now we have to talk about holders in due course. This is a big thing that they like to test on the bar. So of course it's gonna be a thing that we need to know, right? So what's the difference between a holder and a holder in due course? Well, a holder, as we said, has possession and rights to the instrument, right? That just means like it was either bearer paper and they have it and they can cash it in, or it's order paper and it was written to them, signed to them, and they have those rights. So anyone who just entered the room, just know you're gonna have all this stuff. Hopefully we'll send you a PowerPoint, but right now we're talking about holders in due course. So the first holder, who is it? It's the payee of the instrument, right? The first person who received the instrument. And then any subsequent holder becomes a holder. I mean, any subsequent party to it becomes a holder. So the payee is the original holder, and then anyone following is a holder if they gather possession or they're properly endorsed. I know this makes a lot of sense because I understand it, and the way I'm explaining it is basic, right? Like there's a lot of conditions that you might need to know more about, but I'm just trying to make sure you understand the 1 through 9 outline that I have, right? And people who just walked in, it's right here. It's the first thing. Is it commercial paper? What type of commercial paper is it? Who are the parties? Does it satisfy all the conditions? And that's the big one you got to memorize. Does it satisfy all the conditions right here? And then has it been properly negotiated? Now we're talking holders and holders in due course. You got to see if they're a holder in due course. Holder in due course simply means for value, in good faith and without notice, right? A whole bunch of things that you're taking without notice of, but we're just going to keep it simple. If you can literally just write on the bar and get through all these points and just write, a holder in due course takes the instrument for value and good faith without notice, you are saying a lot of really good things that is going to help you get a passing score on this exam. Now, I like to mention the shelter rule. It's got to be like a dominoes. When you're going through commercial paper, each thing triggers something. So holder in due course should trigger the shelter rule. The shelter rule really is I think of it as upstream, that if someone upstream was a holder in due course, then you shall be a holder in due course, right? And then 7, the holder in due course takes free of personal defenses, only subject to the real defenses. I remember there was an acronym, FADES. I don't know, there's so many acronyms. I'm not a big acronym guy, but fraud in the factum, alteration, illegality, incapacity, duress. The S, I could not really remember what it made. That's why I didn't even make the acronym. But if you guys get this PowerPoint, I put a link right here because, you know, I was doing a lot of searching and they really, I think, explain commercial paper pretty well. If you could read this guy or girl, actually, I don't know who Sailor is, but they, I think that's a really simplified way. So if everything right now I'm saying to you is going so far over your head, click this link and read it thoroughly. But everyone should be nodding their heads right now, like, absolutely, Andrew, this makes perfect sense. We have now arrived at a holder in due course. So if we go back to the outline, and I know I'm drilling this in your heads, but it's because I want you to memorize it like I have it memorized. Then after we do the personal, we talk about the real offenses versus personal offenses. Then we go to the last two issues, transfer warranties and presentment warranties. And I'm telling you, any commercial paper essay is going to test you on being able to spit out this outline. That's why I wanted to teach it, because it's very simple in my mind. I'm going to do the same thing with trust. I gave Letty the harder assignment of teaching the really difficult subjects in my mind because they're so, there's just so much volume. But commercial paper is such a narrow outline. And here it is, right? And you got to talk about transfer and presentment warranties. Of course. So let's talk about them. What are presentment warranties, right? Literally, I just copied and pasted these. These are what you have to know. The Florida bar is a lot about memorization. The more you have memorized, the more likely it is you're going to pass. So I'm just going to read them aloud, and then I'm going to pass the mic off to Letty, basically. So what are the presentment warranties? The warrantor is or was a person entitled to enforce the check. The check has not been altered. The warrantor has no knowledge that the drawer's signature is forged. And don't worry about this one, honestly. Okay. And, oh, I'm sorry. I skipped transfer warranties. Sorry, guys. What are the transfer warranties? Let me do this slowly. The transfer is entitled to enforce the instrument. All signatures on the instrument are authentic and authorized. The instrument has not been altered. The instrument is not subject to a defense or claim in recoupment of any party that can be asserted against the warrantor, and the warrantor has no knowledge of any insolvency proceeding commenced with respect to the maker acceptor or, in the case of an accepted draft, the draw. Okay, that's a lot, but again, transfer warranties, presentment warranties. You're gonna have to discuss this when you wrap up a commercial paper essay, and the best thing you could do is simply memorize it. Like, if you don't have these memorized right now, exactly as they're written, I would recommend taking one of these old-fashioned pencils, writing it on a piece of paper, writing transfer warranties on the other side, and flipping it over 100 times until you have it memorized. At this point, the best thing all of you can be doing is just your memorization, making sure you do have things memorized. So transfer warranties we talked about. I read through presentment warranties. Oh, man, what just happened? Okay, thank you. Are you guys going to still see this? Yeah, I ran through presentment warranties. And then if we look at my slide, what's number 10? PYOB. It's a little alteration. Pat yourself on the back. Because if you can go through this entire outline of commercial paper, identifying whether or not it is commercial paper, saying if it's a draft or a note, saying who the parties are, saying if it satisfied all the conditions of negotiability, which I hope you guys all have memorized because that's the key prong right there, number 4. I got to go back to that slide one last time. That is the key thing. You need to memorize all of these because once you recite them, then the essay is going to be about applying them. Was it signed? Was it written? Oh, it was conditioned upon Aunt Sally doing this. Therefore, it doesn't satisfy the requirements of negotiability. So that's the 4th prong. 5th prong has been properly negotiated. Remember, it just needs possession. If it's bearer, if it's order, it needs to be signed. Holder in due course. Remember the holder in due course. It's about good faith is the key thing. And then the shelter rule is the upstream rule. If you got it from a holder in due course, you become one. We talk about real offenses, not personal offenses. Real offenses, I said, fades, fraud in the factum, alteration, etc. Transfer warranties versus presentment warranties. I gave you guys the definition, the things you need to memorize. And then if you literally have done all that on a commercial paper outline, I would tell you to PYOB, pat yourself on the back, because that's awesome. It's very difficult to do that because people are scared of commercial paper. There are a lot of other, we all have these big books that have tons of things in it. But the key to me when it comes to commercial paper is that you guys can do that outline. And it's a hard thing to do, but if I were you guys, I would be praying for a commercial paper essay because I would know that I can confidently drop that outline and it'll be a good thing. So I know you guys, some of you out there are like, wow, Andrew, that was super boring. I know that very well. Some of you guys out there were like, wow, that was very, very helpful because I never even opened the commercial paper outline on my book. And everyone falls somewhere on the spectrum in between. Just know commercial paper is extremely difficult concept, but I think it can be broken down to that basic outline. I really hope the first part of this was helpful. And now, without further ado, I'd like to pass to Leticia, who's going to do Florida Torts.
Hey guys, so just so you understand where I'm coming from, I graduated in 2017, and for the last 4 years, I've been grading essays for bar companies. If you've taken, Themis, Barbary, all of those, like, you may have even gotten feedback from me. So my advice, I think most of you guys know probably the basics of torts and con law. It's going to be tested. So I'm going through more issues that I've spotted in the thousands of essays that I've graded that are big issues where people are losing multiple points every single essay, and it just seems to not really pick up. I would say when I get an essay, the first thing I do, especially you guys that are taking it online in one day, I read the essay and then I outline right away all the topics that I see. So for commercial paper, I would write down those 7 points because I don't trust myself in the middle of a freak out to like know for a fact that I'm going to remember a presentment warranty. But if I write it all out at the beginning, I know, okay, that's something I have to look for. So as far as torts, my advice when it comes to intentional torts, which is, I think, the first leg, right? Is when they give you one, they never just give you one. They pretty much always give you like 100 of them. So whenever you see a ball being thrown, okay, or like some weird scenario, because that's torts, make sure that I would list out all the torts I know: false imprisonment, IIED, NIED. And if I can make a comprehensible argument for any of them, if I can do a however, nevertheless, I say do it. Label each of them, guys. I mean, humans are graders are humans, believe it or not. I do not want to read battery and assault in one paragraph. I don't want to read 30 million intentional torts with no bolded lines all in one paragraph, because I'm trying to go quickly and grade hundreds of these in one day, and I'm not going to be able to give you as many points as you'd like if you're not organized. So battery, give me what's a battery, tell me the definition, paragraph break, apply the facts, and come to some sort of BS or little conclusion. Make the appearance that you're going through IRAC, even if the conclusion is very simple. Because he was in imminent fear, there is an assault, right? So just be very tedious. I think most points that you guys don't realize that you lose is from organization and from thinking that if I write everything in the world, I'm going to get points. There's only points for facts that bring up legal issues. So you may want to write all about negligence per se. If I didn't give you not me, but if the Florida bar didn't give you a statute, it's irrelevant and I can't give you points. Like, I love that you know it, but it's not helpful. So number the elements. As far as assault and battery, please on your essay, if you write about one, you write about the other one, okay? One is a failed attempt at the other, so you need to make sure that you're writing about them, and also transferred intent. It goes in through not all the intentional torts, but through a lot of them, and that's something that some people, for some reason, they do the analysis, but they forget to say transferred intent. So bold it, underline it. We're graders, and we don't have time to find every single thing you're doing. As far as defenses, label them. Let's say that you're doing a defense to an assault. The defense can be Jay's defenses, and then say assault, defense to assault. Like, make sure that it's organized, that you're not just going thing by thing, but that you're putting them together. If for some reason on the exam you get nervous and you forget the specific elements, like you forget beyond a boundary, or you forget at the end if you need a damage, just remember that legal logic goes a very long way on this exam, right? So if you don't understand, if you can't in 2 seconds state the rule, say generally the rule. Because as a grader, I can see that you're trying, and I can see, oh, she messed up one word, but she is trying. She understands the legal logic behind it. There's no points for wrong rules. So there's nothing to stop you from saying it. For false imprisonment, remember shopkeeper's privilege. This is something that a lot of people forget. And remember, it has to be reasonable, okay? If you get a hypo where someone is being held at a store for 7 hours, questioned, maybe even like handcuffed by the security guard, that's not reasonable, okay? So false imprisonment comes hand in hand with shopkeeper's privilege, and a lot of hypos, it does come up on the bar, but just make sure that you're looking for the reasonableness of the detention. For trespass.
Letty, I just want to interrupt you for 1 second. People are asking about if the slides should be moving forward, but I think what you're doing over the next 2 sections, which is torts and commercial paper, is more advice from your outlines than on the PowerPoint, or what would you say?
Yeah, I'm just going through general tips that I found are helpful for intentional torts, for negligence, things that I see are common things that you guys mess up in grading every summer. So,
okay. So yeah. When you started with Florida torts, what you were just on this slide giving general advice about things on the essay that they should write. And what was your, main?
My main thing is that Florida torts is always like someone who throws a ball, who hits someone, who 10 people down the line get injured. And if you're not organized, if you don't tell me titles for each thing, if you don't do P versus J, J versus P, it may be the best essay in the world as far as substance. I'm not going to be able to give you full points, and neither is a grader because it's just too much. So you really need, for torts, you need to break it down because it's factually a heavy subject.
Okay,
that would be my general advice.
And then you were talking about the shopkeeper's defense, right?
Mm-hmm.
And what, some people are like, what in the world is that? Could you just, briefly explain what that means? And
yeah, so in, false imprisonment, you're being held by the defendant in a bounded area with the intent to deprive them of their right to enter and leave. Usually the plaintiff has to be aware of the confinement. And what we see is that the Florida bar sometimes will test a shopkeeper's privilege, which is that a merchant, like let's say you walk into a Hot Topic, throwback, and you go to steal something and one of the employees realizes, oh, he's trying to steal something, let's hold him until the police is called. That is a right within a merchant to do that, but you need to be very aware that it's not an unlimited right. And sometimes people will abuse that. So yes, if there's reasonable suspicion, I believe someone just asked, of a crime being taken, a shopkeeper is within his right to do that. So it's called their privilege, their shopkeeper's privilege.
Great.
Next is trespass to land. Just remember for that one that you don't need damages. I often see that people will say, oh, in this one, it's probably not trespass to land because, there was no damage. Any sort of physical intrusion into the house is sufficient. So just, that one's a little different than the rest of the other intentional torts. For defamation, make sure that you go.
Letty, I'm sorry. So just to keep it organized, because I know my slides have more just detail and I'm just trying to help people get the most value from listening to what you're saying. So you were just going through the intentional torts on beforehand, or when you were talking about intentional torts, right?
Yeah, I was going through only intentional torts.
Okay. And all right, and so yeah, please continue.
Okay, so for defamation, I think it's really important to think about whether there's actual malice and whether it's a matter of public concern. I've noticed that a lot of people will go through the analysis. There's, oh my God, give me a second. For some reason, the dog, no matter where I put it, it is. So give me 1 second. Give me 1 second.
No, that's okay. And so a lot of people have been emailing me right now for the PowerPoint. Sonia, are you here? Is Sonia in here? Because I'd like to, I know for her sections, the PowerPoint might not be as helpful because she, the value of Letty is that she's a test grader. So she's seen a lot of these essays. So when she's talking about torts, which I'm sure you guys know all the torts and all the definitions, she's just trying to help people about, yeah, all right, thank you, Danielle, thank you so much. All right, so Letty, continue on about intentional torts.
Okay, so yeah, my point is just to give you guys the tips that I've seen. So for defamation, a lot of you guys do a really good job. Defamatory language published to a third party ruins someone's reputation, but you forget that distinction between public and private and sort of the mental element. It's something the bar has often discussed and has put in as a sub issue. So make sure when you're looking at defamation, don't forget to say who is being defamed. Is it a government figure? Is it someone who's put themselves in the public light? Or is it a Joe Schmo, right? Just make sure you keep that distinction. Obviously, intentional torts do have defenses. Believe it or not, oftentimes people get so wrapped up in writing about the elements and the facts, they totally forget to write about consent or self-defense, right? For consent, that's one that I think comes up and people don't do as well. Let's say this is a topic one, popular one that comes up is you have a hypo where, it's football, so there's an implied consent that people would hurt each other, they would touch each other, but one player takes a football and crashes it over someone's head after the game. So even if there was consent for entering into this sort of risky behavior where you could get hurt, that consent was exceeded when someone after the game placed a ball over someone's head. So just think about consent the scope of the consent. Did someone exceed that scope? Because oftentimes people will write, well, he consented and that's it, but there's a sub issue that maybe this person took it a bit too far. So we can move on from intentional torts to negligence. All right, everyone knows negligence at this point. I mean, you guys know them by heart. You're probably breathing them. But what I need you to do is to divide the elements into 4 sections. I mean, you can, look, take what you want. You cannot do what I'm telling you. I'm telling you as someone who grades, it's very easy if I can see duty, breach, causation, damages, right? Within causation, put actual causation as a subheader. Put proximate causation as a subheader. Give me the relevant rules for both. If you tell me there's actual cause, but you don't tell me the but-for test, or you tell me there's proximate cause, but you don't explain foreseeability, I can only give you half the point. So make sure that just because you know it, and it's so obvious at this point what proximate cause is, doesn't mean that the grader knows it, but they can't assume, right? I can't assume for you that you know what proximate means. So just make sure that you divide within each entity what you're going through. And as far as the points, I haven't graded for the bar themselves. I saw there's a question, but I can tell you that at STEAMIS and different bar companies, we can't give you full points unless the rule is complete. So that's where I'm coming from. So that's the main thing for negligence. Florida statute. If you see a Florida statute, there's a Florida statute that says that parking your car with the tires when you're on an incline should be to the right. Florida statute comes up, you know that in addition to a negligence analysis, you need to do a negligence per se analysis. And you need to tell me who's the type of harm and the type of people. Oftentimes people will say, oh, it's negligence per se because it's a Florida statute. No. That's the beginning of the analysis. Good job figuring it out. But then tell me, is this the type of person? So if your tires, let's say that the law requires the tires to be to the right on a slope. This is, I think, from a few years ago. And then all of a sudden someone hits that car and it explodes. That's not the type of harm that statute was trying to prevent. So make sure that it's the type of person and the type of harm. Don't assume that because there's a statute, the analysis ends. That's the beginning section. And remember, if you have negligence per se, do a negligence analysis. They come hand in hand. It would be like doing due process without discussing equal protection. Just throw it out there. Throw the baby, throw the, like that whole saying, throw everything out there. That's what's next. Products liability. Okay, so for this one, the main issue I see people having is that not everyone, but a lot of people are really bad at being able to actually tell me what are the 3 different. So we have manufacturing defect, a design defect, and an inadequacy to warn. And oftentimes I see that there's a hypo with, let's say, what do you call this? A hypo that says this is a warning label, okay? Just because it has a warning label doesn't mean that that label isn't inadequate. So please don't fall for that, right? On the bar, there's a warning label, but it doesn't address children. And then the person who's harmed is a child. And there should have been a warning label. So the label can exist and still fail to warn sufficiently. So just don't be tripped up if you see a warning label, you go, oh, well, obviously it's not a failure to warn. No, it could still very well be a failure to warn adequately. And then the last thing I have here are the implied warranties. Listen, I just need you guys to realize that when there's one, there's 10 of them. So if something doesn't work a certain way, it's warrantability, right? Merchantability. But if someone makes a statement like, oh, this would be great for your tires, then you know that it's fitness for a particular purpose. Don't get caught up in the fact that you think it's only one, and then you fail to do the analysis under all 3. Remember, in real life, as a lawyer, you'd be like, yeah, I mean, it's obviously fitness for a particular purpose. But really, you need to tell me all 3 because I want to give you the points. So that's what I wanted to tell you for torts. For con law, we can keep it really simple. I know that you guys have been studying Florida con law. That's the essay that everyone, for the most part, does very well in, believe it or not. So homestead. What I want to tell you about homestead is if you don't write that homestead rights are liberally construed in Florida in favor of the debtor, that's like just such a basic point. It tells the grader that you have a general understanding of the subject. Homestead is something that the Florida bar graders love to test. It's very specific to Florida, right? So when you get a set of facts where you're going between, you have somebody who lives in Florida but also resides somewhere else, just make sure that you don't assume that it's not homestead. they can go to a winter home and still have a homestead in Florida. Don't stop your analysis. I see a lot of people just say, oh, this is not their homestead. And then they didn't talk about the acreage limitation. They didn't talk about devisees. They don't talk, whenever homestead is discussed, think about it as a holistic subject, right? You have taxes you need to talk about. What happens with alienation? What happens to your creditors, right? Homestead comes with like its buddies, okay? So once you see homestead, you should be really, really, really happy because you know you got to talk about like 5 things automatically. So that's homestead. What's next? It's sunshine.
Yeah, Letty, someone asked about the first rule statement about liberally construed.
Homestead rights are liberally construed in Florida in favor of the debtor. And just remember that, because at the end of the day, that is what homestead is trying to do. It's trying to protect Florida citizens or Florida residents from being homeless, essentially. And you know, we don't want a bunch of homeless people. We don't have anywhere to house them. So it's one of the benefits you get from Florida. As far as sunshine law, I believe that's next.
Yes.
Okay. For some reason, this is a sub issue that a lot of people miss. Essentially, just because there isn't discussion on it in the issue, like let's say that there's a meeting and then from that meeting comes a law on the hypo. Remember, if there's a meeting, if there's a formal gathering, if there's anything of value that comes from a governmental meeting, you have a right to know what happened. You have a right to notice. You need to discuss it, okay? Even if it doesn't seem like it's the main issue, because you're like, oh, well, I mean, it seems like they sent notice out. Well, tell me. Assuming proper notice was sent, assuming that people were able to attend the meeting through a public hearing or something, then the sunshine law is met. Don't assume because it's not the main issue in the essay that there's nothing to discuss, right? And then the next thing is general and special laws. Okay, I'm sure that a lot of you guys have heard about general and special laws at this point. General law applies uniformly across the state. Special laws apply to a specific subsection of the state. What I need you to look out for is the general laws of local application. This is the tricky part. This is the part they like to test. If you see a population, like let's say in Florida, this law will only apply to areas that have over, 500,000 people. And that's only Miami-Dade County, for example. Then you have a general law of local application. And in essence, there are certain requirements that come with that law because it's only being applied to a specific subsection. So don't assume that just because the law appears to be applied uniformly, the bar will give you something that should tell you to go, oh, wait, is this only going to apply in Broward County? Because if it's only going to apply in Broward County, where's the notice? Where's all the specific requirements that come along with it? So whenever you see a law, the first thing I do in my head is this a general law, a special law, or a general law of local application? And then before I even start thinking about the constitutional issues, I go through the procedural and substantive duties of a law. So procedural, is it clearly worded? Is it not vague, right? Can the average person conform their behavior accordingly? And is it reasonably related to the health, safety, and well-being, right? So go through the 3 procedural requirements, and then don't forget the substantive requirements. This is tricky, and for some reason, people always just write about, oh, the law is violating due process. Okay, well, the law didn't have a single subject, and the law wasn't read into the record 3 times, and the law didn't pass both houses. Like, go through, even if you don't, even in absence of fact, let's say the hypo does not list any of these things, you say, assuming that the law meets both the procedural and substantive requirements, then it would be correct. And then you can move on to your substantive issues. So I just don't want you guys to get like really boggled down and just honestly give up really easy points that you can take. Take the easy points where you get them. And that's it. That's the main issues I see, believe it or not. As far as general tips for the essay writing, use your time effectively. If there is a 1-line sub-issue about like, I don't know, a random topic, it should not be 80% of your essay. If all the facts are about one group of people being treated differently because of their race or their height, it's an equal protection essay, okay? And you may want to write your whole outline, but most of the points are going to be in equal protection. So look at the facts. The facts dictate about what you write about. So every sub-issue, discuss it in light of the amount of facts, okay? And, use mnemonics just to remind yourself. I find them very helpful. I know Andrew said he doesn't love them. I find them very, very helpful. So just make sure that you use mnemonics throughout. And when, like I'm telling you, when I get nervous, the first thing I do is I write down every sub-issue I see. because later on, God forbid, that clock is ticking. I'm like, oh, yes, I saw equal protection. Oh, yeah, I saw access to courts, right? So just, you know, you guys are going through a lot. Like, we're in a pandemic and there's no jobs. So it's a lot, right? So just make it easy for yourself by just listing it out and then going little by little. Other than that, I think you guys are going to be fine. So,
Letty, there's a couple questions. Jessica said, can you talk about some of the substantive issues in regards to GLA?
substantive issues regarding to general laws of local application?
I believe so. That's what she wrote in the group chat.
Well, I mean, the way I think about it is just like the Florida legislator trying to be sneaky, right? Like, you're trying to pass a law that's only going to apply to Miami-Dade County, but you don't want to go through the referendum requirement. You're not trying to go through the notice requirement, but you make it so specific that it's only going to end up applying to one. So whenever I see some sort of, honestly, it's usually population, but it could be other things. I go, oh, wait, ... Can this be a general law of local application? If so, let me write it, put a buzzword on it. Worst thing worse, I don't get points for it, but I don't lose points because I didn't put it in. So, you know, overly analyzing is never going to hurt you. So yeah, and let me know if you guys want to do a session before Tuesday. I'm open to it, but just calm down, relax, and keep it simple. Okay? That would be my go-to.
Yeah, awesome, Letty. And I know she got tons of people in the comment section saying how much they love you. So I want to make it clear I love her too. Like, we are a team. I think when you walked away with the dogs, I said something about your slides and just making sure they were listening. And then everyone came in to say how much they loved you, which is the best thing that I could possibly hear, because Letty is the director of our bar department. You know, at IBIS Prep, we do the Series 7, the LSAT, the GMAT, GRE, but the Florida bar is really just me and Letty, and Letty's done an amazing job working with people. And now people are saying how great I am, so thank you. No, I'm just kidding. Okay, so you know, this last issue, I really want to unmute everyone because I think it would be best if we had some input from everyone before I even, you know, actually no, let me rewind that. I'm gonna quickly go through trust as I've always learned trust, but then we have to talk about the recognition that trust is going to be tested this year in multiple choice and not in the essays. And that is something, you know, I have a tutor who I just messaged, why are you not here right now? And he said he's studying Civ Pro, so I can't be mad at him, but he is my LSAT tutor. And him and I have been talking every day because he is studying for the Florida bar. He's taking it as well. So that's how I've really stayed in tune with all the madness. And, you know, he's the one who's saying, all of his friends and buddies have been saying that's the key thing they want to know is how should we be preparing for trust in that it's being tested differently than it's ever been tested before. And the answer is it's a collaborative effort. I mean, I would say no trust better than you've ever known them before. And, you know, everyone's looking for where can they find hypotheticals. I mean, at the end of the day, hypotheticals are good, but knowing the ins and outs of trust is even better, because then the hypotheticals just become realities that you will encounter. You know, for a lot of people out there who don't know what type of law they are going to practice, estate planning is a very solid type of law, especially with what's going on today. And a lot of people need help in that regard in how they're going to, you know, deal with unknowns in the future. So people are scared of trusts and wills and such, but I think it's one of the most interesting parts of the law. So I'm going to do this very quickly, like I said, because I'm going to send you the PowerPoint. Everyone who sent me an email, I already forwarded to our marketing team to send you the PowerPoints. This is all love and trust. I mean, we would have done it for 3 hours, but you know, there's a lot of football on today. But we are here to help you guys, and I want to open up the floor so that some of the people who feel confident about what they're doing with trust, if you send a copy of the PowerPoint, let me just put this one more time before I lose it. Andrew@ibisprep.com. That's my email. You guys should all know that IBIS is the local bird down here in Miami, and prep is what we do. We prepare students, or test takers, as y'all are called. So trust is going to be an issue that's different because it's tested on multiple choice. And I want to hear from the confident people. I want to hear from the not confident people. I want to open up the floor. So just like I went through the commercial paper, okay, Sorry, someone sent me a private message. I'm sorry. Just like I went through and I think they meant to send it to someone else. But just like I went through the commercial paper outline, this is what I would have done on a trust outline. The settlor, the intent, the trustee, the race, the ascertainable beneficiaries, the valid purpose, and understanding that real property, of course, statute of frauds must be in writing, and testamentary trust too, with a condition of 2007. I put some key terms for trust, things that people get confused about. Like, what is an inter vivos trust versus testamentary trust, right? Inter vivos while they're alive, testamentary upon death. Revocable can be changed. Irrevocable cannot be modified without the consent of beneficiaries. I mean, when you are someone who's looking to put their money away and not have it touched by anyone, irrevocable trusts are the way to go, right? It's interesting that we talk about homestead exemption because I always think about O.J. Simpson, right? He was someone who knew that his estate was going to get severely lessened. So what did he do? He got a huge house in Florida before he did the deed, which was, of course, not in a municipality. So he was able to have a huge estate that was untouchable. And he put a lot of things in an irrevocable trust. He bought life insurance, like all these different things that you can use. But irrevocable trust is the instrument that is the most difficult to pierce, right? This word, I want everyone to use this word. Well, it's not an essay, but precatory language. If you see that word on multiple choice, just know that precatory language refers to, it is my hope that they will give the money to someone. That is not real enforceable language. That's only precatory. And then the other thing that if it was essays, they would hammer you on, it would be spendthrift provisions, which are basically these provisions that shield accessibility. So nobody can access it if there's a spendthrift provision, except a few people that we will talk about in my next 2 slides. All right, other types of trust, these are just like, this is good because it's multiple choice. You will probably see these things. An UTMA, there's also something called an UGMA, which is the Gift to Minors Act, but UTMA is more common because it's a transfer to minors. And that's basically you set up a trustee until they're 21. I mean, rich people do this, wealthy people do this because they don't want their kid to be spending money on who knows. They want them to be only getting a certain amount, and then they turn 21, and then they can access it entirely. They'll have a custodian. I didn't mean trustee, I meant custodian. And then there's the gift exclusion. So we have constructive versus resulting trust. A resulting trust arises if an express trust falls apart, whereas a constructive trust arises to prevent unjust enrichment. We all know a lot about unjust enrichment. Secret versus semi-secret trust. Secret trust is like, it's written in the will. You didn't really, that's why it's called secret. You didn't really know about it, but then you found the will, and there was a full intention to create a trust. A semi-secret, and that would be enforceable. Semi-secret would be like they mentioned the creation in the will, but they don't mention the beneficiaries. That obviously wouldn't be enforced because, not obviously, but that wouldn't be enforced because we don't have the beneficiaries. A token trust is also payable on death account. And a pour-over trust. You also hear of pour-over wills. These are basically where you can just add to the trust during the life of it. People are saying, what's one way you can study more for multiple choice? I think knowing more just keywords and definitions, because if you know what the meanings are, you'll be able to approach the answers. As someone who is, my life is test prep, LSAT, GMAT, GRE, whatever you may call it, it's my life. I have strategies for multiple choice. I love the MBE because multiple choice is all about why are the incorrect answers incorrect and why is the correct answer correct. There's 2 ways to get a correct answer. If you can eliminate all the wrong ones and be left with the right one, that'll get you the right answer. Or if you know for a fact the right answer is correct, then that will get you the right answer. So the more definitions you know in your head, the better off you'll be, because what they love to do is put a word that you've never seen before. Well, it'd be great if you have seen it before. So that's why I recommend definitions. Okay, penetration of spendthrifts, child support and spousal support, the key, and then these other 2, not too important, really. I don't know if I'm seeing that. Nemo dat. All right, I just wanted to add this last thing, Nemo dat, because I'm in a business group, and the trust attorney had a Nemo dat case, and it's just to prove something to a lot of people in the room, that there's still things to learn every day. Even if you think you mastered this, keep stretching it out for at least today, and learn as much as you can. And what is NEMO that? It means you aren't allowed to transfer things that you don't have the right to. So if you, try and transfer the right to your neighbor's house, well, you really couldn't do that, or there's a whole different way. So I just want to include one more Latin rule. It's not important for the bar exam, but I'm just saying, if you think you know everything, there's always more to learn. But you know what? I really want to open it up right now. Does anyone have any thoughts about trust being tested as multiple choice? Is there anyone in the room that would like to speak? Don't be shy.
Hi, everyone.
Hi.
Can you hear me?
Yes.
I think it might be easier. Easier, not really, but a little bit easier as multiple choice because you have the answer there. There is an answer. There's always a right answer. And once again, like you said, if you know it, if you are familiar with it, things can jump out at you. Yes, with essays, it's easier to be able to kind of throw the whole, kitchen sink in there. But I think with the multiple choice, because it's trust, and remember, it's 100 multiple choice questions and it's 7 subjects. So it's really not that many questions that you have to get through. As long as you know, I guess, the nuances of what they're talking about, it's easy to pick the answer, or it's easy to at least identify or eliminate the wrong ones. So that's just my 2 cents.
Great. I would harp on memorizing and understanding more words and definitions, because I like essays and multiple choice, because there's different approaches to them. But with an essay, you can BS it a little bit, right? You can say, all right, I know a little bit about this. I could use a little twist of the tongue to kind of make things happen. With multiple choice, you're really tasked to actually know the answer. So with that in mind, I would go back to trust and make sure, all those little subpoints that, for something that's only going to be an essay, you might think I don't need to know. For trust, I might at least become familiar with them so that if you see them on the test, you know what it means. Because the worst thing to happen on multiple choice is to get 4 answers of like phrases that you've never seen before. And then you're like, I don't know what they mean. So how could I even answer the question? So just, more in-depth on terminology. So, people are saying I really feel they're going to test wills since there's so many crossovers of trust. That's a valid point. I would see that too. I think, wills and trusts should appear on the exam. They appeared when I took it. To give you an idea of what my essays were, and Letty, you could chime in. I know I had a property essay that was very difficult. I had a trust essay that was so easy. It was regurgitating the essay that I showed you guys. And then I had, exactly as Letty predicted, a con law test that did have a sunshine issue, and also was about the actual specifications of a bill that's going to become a law, like how it needs to be written. Letty, what did you experience on your essays?
I had commercial paper and I died inside. That's how I felt about it. I had Fed and Florida con law, which at this point it comes up so often. I think it's such a good place to spend your time. Florida con law, Florida torts, they're tested upwards of 80% every year. And then I had dependency, which you guys don't have to deal with, and I don't know why I had to deal with it. So yeah, I would say you guys actually have a very good idea of what's coming your way. So
right. And trust me, I am not in any way a spokesperson for the Florida Board of Bar Examiners. I know that there's a very difficult test because Florida has a saturation of attorneys. My neighbor to the right and to the left of me are attorneys. There's a lot of attorneys in Florida because people come and retire. It's sunny here. There's no income tax. Everyone wants to be an attorney in Florida. So they do have, a responsibility to have a difficult exam. Do I think it's too difficult? Probably. But what bothers me about the normal rendition of the exam is the uncertainty. So in that respect, at least you guys do have somewhat of a clearer certainty. And now trust me, I would never take your circumstance over my circumstance. You guys have been tossed a real curveball. You've had to endure months of studying. You guys should be working in the field by now. But at the same time, life comes as it comes. This is going to better prepare you. You're going to get the score you're going to score, so you just got to be prepared. But I agree with what Letty said, that there is more clarity in what's going to be tested. I would have the mind state that everything's going to be tested. Don't try and sacrifice a single section playing, a gambling game. I don't think that would be the proper methodology. But what would you say, Letty?
Yeah, I mean, I just feel like the one benefit they have given you is they've cut it down. So you really have the next few days to go through the basic rules, be able to walk your way through a commercial paper essay. I mean, I hate the subject personally, but I know that these are the 5 things I have to hit. And if I hit them all 5 times, then I've probably gotten enough points to pass the essay, because I'm not trying to book the class or get an A. I'm trying to pass, right? And passing is just being right there on the curve. So go through the main often tested issue. Don't spend the next 48 hours in the weeds about a sub issue that, maybe you'll get you 1 point, but you couldn't explain due process, right?
Sure.
So that's my point.
And I would love to hear from Susie, because she said she passed Florida. What were your thoughts that you're mentioning to the group? Susie.
Hey, can you hear me?
Yes, we can.
Yeah, I had passed Florida in July 2018, and my problem has been the multi-state, and I kept failing it by 1 point.
Okay.
So it's been really frustrating for me. But when my essays were contracts with ethics, it was federal con law, it was a protest, and there was some Florida con law mixed in with the federal con law, and then the other one was dependency and family.
Okay.
So obviously we know dependency and family is not going to be on this one. But I'm thinking that according satisfaction for commercial paper might be something that they can put in there with contracts and ethics. It also hasn't been tested for a little while. I think as well with federal con law, we could be looking at maybe some sort of religious liberty, as well as the protest could really come up again, because that's been 5 bar exams since they covered First Amendment.
Okay. Yeah, I appreciate that, Susie. I know we're getting to the end of time, so I don't mean to cut you off, but
I know that's
yeah, thank you very much. And to her point, it's a tough test. People aren't always going to pass it, but the best way to ensure the best probability is to over-prepare. That's our motto at IBIS Prep, over-prepare, over-perform. You guys are asking a lot of questions right now, and I don't want to bog down, because I was really intent on keeping this succinct to 1 hour. But like we said, from now until test day, we're available. Letty and I, we do, at this point, sessions by the hour. If anyone wants to do a private session with us, just reach out to us and let us know. And we're here for you. We're going to send you, everyone that's emailed me is going to get this exact PowerPoint. Follow us on Facebook, Instagram, and LinkedIn. We're available. You can message us anytime. This quote from George Washington Carver about 99% of the failures come from people who have the habit of making excuses. Just be positive, guys. Don't try and say, what are the uncertainties? What can I prepare for? Let's just spend the next couple of days focused on mastering any material we don't know, on being mentally prepared for this test. A lot of people say, should I study the day before the test? That's a really personal question. Yes, I studied until the last minute, because that's how I operate. Some people take the whole day off to go to the sauna and the spa to be, in a mental place. You guys are all at least 22 years old. You know yourself and how you perform. So at least spend the rest of today tying up any loose ends and making sure you know everything. We're going to send you these PowerPoints. We're going to post this entire lecture on YouTube very soon, which is great for all the pointers that Letty had. Commercial paper, I gave you guys hopefully a good outline for. And then for trust, it's the same basic outline. Just understand the key points and just go over the definitions more to prepare for the multiple choice. Letty, is there anything that you want to add?
I think as a general tip from, tutoring a bunch of people is, don't spend the next 2 days regretting, had I spent more time, had I done this? I mean, you didn't, and that's fine. Not being negative, but you didn't. So what I would say is, what can I do in the next 48 hours to maximize the time I have? Because, you know, like crying over spilled milk isn't going to help you. So that's my 2 cents. Just 48 hours is a lot. People learn entire law school subjects in 48 hours before a final. I mean, maybe you're not one of those people, but a lot of people, I was one of those people. So really, you know, go hard so you don't have any regrets.
And Letty, yeah, they're saying, what's your suggestion to do between now and the exam? I mean, we can both answer this. What would you suggest?
I would suggest just going through each subject and looking at, I know Barbary has a very good list. I think it's their small little green book of often tested subjects. But at this point, you guys know the often tested subjects, and I would just read them over and over again. Because, yeah, people love the mini rules and the exceptions, and that's cool, know them. But definitely be able to write, you know, in a very legitimate way about every subject, like homestead, that, you know, if it comes up, everyone can write about homestead at this point. So in the subjects where everyone's going to be able to write, make sure your writing hits up there. In the subjects that you're going to be thrown off because it's a minor rule, everyone's going to be thrown off, you know?
That's great. And, you know, as a businessman, I would recommend reaching out to Letty for a 1 hour session for $75 an hour to really fine tune any subject that you're struggling with. But as a friend and as someone who wants the best for you, I would just recommend, you know, tying up the knots of any subjects you're struggling with and just getting a little bit better today, getting a really good night's sleep. And then tomorrow, it really depends on what type of person you are. If you're the type of person like me, I take tomorrow as a full day of studying. If you're the type of person like my roommate was, then I take tomorrow to just unwind. Don't drink or do anything that might affect your mind, you know? Remember, your mind has to be as clear as possible. I would really focus on that. I really wish you guys the absolute best of luck. I want everyone to pass. I have you guys, if you've contacted me, you sent me your email, just know that like my phone is on my hip. I feel bad because people are messaging me and I haven't messaged you back, but as the owner of this business, I take pride in open contact with everyone. You know, you can message me out. I'm a young man, so like you can say, yo, what up? I'll respond. Let's rock and roll, guys. Let's keep the positive vibes up. Thank you all so much for joining me today, and I wish you the absolute best of luck.
Thank you.
Thank you, Letty. And everyone, yeah, Letty, she's amazing. I know she's amazing. Thank you so much, Letty, for your contributions today.
You got this. Keep it up, guys. Go hard.
All right. Thank you, everybody.
Thank you, everyone.
Hi, Andrew. I emailed you, or I sent you my email. I
Yes.
guess to get payment instructions. I would like to do, like, if you have availability for tomorrow morning with Letty. I just
Yeah.
want to do a quick recap. I don't feel too comfortable with property. It's kind of like an abstract subject for me, so I don't feel too comfortable with it. So I would like to, you know, do a recap with her, if that's
All
possible.
right. 1 hour lesson in property, you said about 9 a.m.?
Yes.
Okay, no problem. You know, from my perspective, property is tough. I found property to be, you know, we couldn't have done property today because it's not a 15-minute presentation. So I understand that, but I think if you did a 1 hour session with Letty on property, then she could at least, you know, have the main points. What's giving you so much difficulty specifically in property?
I just read the outlines, and then it's so hard for me to like grasp like what I have to write on the essays. For example, like I went over an essay and it was like a full adverse possession essay, and like I missed the entire subject because it wasn't like in your face. It was kind of like it was very hidden in the facts, and you know.
I'm right when this ends and before the football game starts, I'm gonna call Letty to schedule that appointment for you because she's great at that, at issue spotting. It doesn't sound like you're struggling with the material. It's just, I mean, maybe a little bit, but more, you're just not seeing the issue when it confronts you. So that's something that she could definitely help you out, man. And I think you'll be fine.
All right, and would 9 a.m. work?
Yeah, 9 a.m. I'll get right back to you.
All right,
I'll
well, I
put
can use
that
my
down.
email, so you can
Yeah.
just communicate with me via email.
Thank you. It was a pleasure.
All right, man. Thanks a lot.
No problem, man. Anyone else have any thoughts or questions who's still hanging out? All right. I guess that's a wrap. Well, Michelle, hey. Yes. Michelle, you're still here. Absolutely. Are you here, Michelle? I'm going to give you my...
I am. Yeah, can you hear me?
Yeah.
Okay. So I hadn't studied enough for the Florida bar the first time around, and I knew it, but I decided to give it a whirl to see if I could pass, and I failed by half a point. So I got in the 60s on 2 of my essays, but my property was in the high 20s. And I felt like I understood it. I still feel like I understand it. So I'm thinking a property essay hour session with Letty might be what I need to kind of get up there.
So if you just saw, I mean, I have to call Letty right now and just confirm.
Yeah.
But this guy, Matias, is doing a 1 hour session at 9. So hers would probably be about 10:30. We don't like to schedule them on top of each other. But
Okay.
yeah, we could absolutely do that. Here, I just sent, it's just me and you in here now. I just sent my message, my phone number in the message. Could you just text me your name and just recite that you wanted to do a session with her at 10:30, and I'll set it right up.
Wonderful. I'll text you right now. I appreciate it. This was great.
Thank you so much, Michelle. I enjoyed it too. Have a great day.
You too. Take care.
Bye.